Thank you, Your Honor. There's a whole list, and so what I would like to do is make all of these objections pursuant to Mr. Holmes's due process rights, rights to a fair trial, and rights under the Eighth Amendment. And then for each objection, I'll tell the court which evidentiary rule I'm objecting under.
Okay, thank you. That would be great.
I anticipate that Ms. Mosier will testify that she dropped her daughter Veronica off at the babysitter that afternoon so that she, Ashley, could go have an ultrasound. And I would object to that under 401 and 403. Do you want me just to do the whole list?
Actually, can you give me just a second so I
Yep.
can take notes? Okay, what's the next one?
She was excited about the new baby and wanted to go celebrate. 401 and 403.
Okay, go ahead.
She thought that the Batman, she being Ashley, thought that the Batman movie would be a kid's cartoon, and when she realized it wasn't going to be a cartoon, she thought, oh my gosh, I hope Veronica won't be scared. .401 and 403.
Okay, go ahead.
At the theater, Veronica wanted to sit on her mother's lap, and Ashley, since she was pregnant, did not want Veronica to sit on her lap because it was uncomfortable. And so the last thing that Ashley said to Veronica was, no, you're a big girl, you can sit in your own seat. 401, 403, and hearsay.
All right.
I expect the testimony to be that when Ashley Mosier was shot, she fell on top of Veronica, and then Ashley Mosier was asking the cousin, I believe her name's Kaylin Bailey, whether Veronica was breathing. I'd object 401, 403, and hearsay. And then also to that, Kaylin Bailey's response, I don't know.
All right.
Kaylin Bailey asking Ashley Mosier if she could move off of Veronica, and Ashley Mosier saying that she couldn't. 401, 403, and hearsay.
Okay, what's the next one?
When Ashley Mosier was being carried out of the theater, her pants fell down. 401 and 403.
All right.
When Ashley Mosier got to the hospital, She remembers one of the medical personnel talking about performing a CAT scan on Ashley Mosier, and that Ashley Mosier was pregnant. Hearsay 401 and 403.
Okay,
At the hospital, Ashley Mosier asking her mother about the status of Veronica, and the mother telling Ashley that they were taking care of Veronica, and that Ashley finally found out on Sunday that Veronica had died. Hearsay 401, 403.
all right,
Ashley being told at the hospital that she lost her unborn baby. 401, 403, hearsay.
okay,
That they had to remove the upper left lobe of one of Ashley Mosier's lungs, and that she still has to use oxygen at night. 401 and 403.
excuse me.
Bless you.
All right, any others?
She still has bullet fragments in her body and spinal cord. 401 and 403.
All right,
She had to stay at the Craig Rehabilitation Center from August of 2012 until December of 2013. 401 and 403.
okay,
Your Honor, and then there's a string of things that she had to relearn how to do. I can give those to the court one by one or in a group. It's up to the court. Examples are how to use a spoon, how to transfer from the wheelchair to the bed, how to learn how to sit because her balance was bad, how to learn how to do quad coughs to get fluid out of her lungs and throat. I think they had her do something in a standing frame to keep her bones strong. She had to learn how to make a sandwich. She did physical therapy 3 to 4 times a week at Craig and no longer does the physical therapy. Accommodations that have had to been that they've done to enable her to use the restroom, bathe, dress herself. She's fallen a few times since then. She's had subsequent infections. They had to delay Veronica's funeral until a time when Ashley was able to be more involved in it and that she was unable to help plan it 'cause she was in the hospital. There are details about her funeral. I don't know how far the prosecution intends to go, but these are, she still has nerve pain. And that would all be under 401 and 403. And then we would object to showing Ms. Mosier a picture of Veronica and asking her if she ever saw her daughter alive again. As the court knows, the death of the child strikes a particular chord for a lot of jurors. We're not disputing Veronica's death. The jury has heard a lot of information about Veronica's death, and it just seems that this is unduly prejudicial compared to its probative value. Would ask the court to exclude all of that.
All right, thank you. Who's going to respond? Ms. Stitch McGuire?
Oh, Your Honor.
Okay. And maybe the easiest way to do it is to go in the same order, and you can tell me whether you are intending to introduce the evidence that Ms. Brady talked about as to each category, and if you are, what the response is to the objection.
Yes, sir, thank you. Just to capture overall, I think Ashley Mosier Sullivan represents a unique witness in this trial. We have had perceiving witnesses from the theater who suffered no injury. We have had witnesses who were victims of the defendant's conduct and have been injured and were able to talk about it. And we have had witnesses that were able to talk about the deceased that they were with. Ms. Mosier Sullivan represents a combination of all three. She's not only a perceiving witness, she was one that suffered a significant injury and also was the parent of one of the defendant's victims in this case. And so she is a unique person when she hits the stand here, Judge, to testify. As to the initial things that Ms. Brady brought up about her dropping her daughter off at the babysitter and the fact that she had gone for an ultrasound, they were excited, and they thought that, she thought that Batman was a cartoon movie. These are all things, Your Honor, that put into context for jurors how they got to the theater that night and why a 6-year-old girl, and we've heard about other children, would be at a Batman movie at midnight on a Thursday night. It also goes to put into context some of the later testimony about her injuries, including her miscarriage. There is nothing gratuitous about that. There is nothing that is unfairly prejudicial to the defendant. And that's the other portion of this, is that I agree with Ms. Brady. It is a horrific thing to deal with the murder of a child. That is what the allegations are in this case. So there isn't any way to pick apart all the other surrounding evidence to say, let's minimize the emotional impact of killing a 6-year-old. The fact that she does not want her to sit on her lap, Your Honor, is significant and arguable because it explains why she was in the seat that she was in when she had an alternative, when she suffered the 4 shots to her body that the defendant put into her. That's significant. The fact that there was...
Who was in that seat?
I'm sorry, why Veronica was in her own seat when she had wanted to sit on her mother's lap. It puts into perspective for the jurors what was going on, why she ended up being in that seat by herself. And she ends up getting shot in that seat or right there as Mom's trying to pull her down. There is an objection to whether or not Veronica was breathing, and it was whether or not Ashley could perceive her breathing and her statement afterwards. And I think, Your Honor, that's a present sense impression that she has. I don't think it's hearsay. I think it goes to that moment when her thoughts, her only thoughts, as she's on top of her daughter, are, is she breathing? The statement that she couldn't move, and I'm willing to accept that the question by Caitlin, can you get off of her, maybe hearsay, maybe that doesn't come in. But
I think before that,
yes, sir.
the statement by Caitlin, I don't know, in response to the question about whether Veronica was breathing.
It's possible it's an excited utterance, Your Honor, and we'd have to lay the foundation for that, but I'm not wedded to that, Your Honor. There's also, the fact that Caitlin doesn't know if she's breathing has some relevance and significance, but again, Your Honor, it's a hearsay statement. It may be an excited utterance. And I'm sorry, Your Honor, I was addressing the
question by Caitlin, if she could move off of Veronica.
Right. I think the reason that is admissible and comes in and isn't 403 is it then leads to the victim in this case, Ms. Mosher-Sullivan, to try to move and realizes she cannot move. And this explains her then response, no, I can't get off of her. It's a measure of the injuries that she sustained immediately after the shooting. Her pants fell down as she was being taken out of the theater. Your Honor, I don't know that that's unfairly prejudicial. It's simply a fact of how she got from the crime scene to where she ended up being treated. It is a reality of the situation that was created by the defendant. The statement by the medical person that they wanted to CAT scan her because she was pregnant, All right, I do think that's a hearsay statement. I don't have a good answer for that at the moment. Judge, if the court would permit, I'll try to think of something overnight, and I know the court's going to think about this too, but I think it's hearsay.
I think it is too.
Yeah, the mother telling her that they're going to take care of Veronica. Well, I think that is the reality of the situation. And I think it goes to try to assuage the angst that she's going through in the hospital. And Judge, you'll remember this was the objection where the mom, I think, is coming to see Ashley and saying, hey, they're taking care of Veronica. I think that is likely also hearsay.
So you agree that that's hearsay?
I think it's hearsay. I think that the issue, though, of her finding out on Sunday, being told that her daughter died, Judge, I do think that's relevant. I mean, she finds out at some point that her daughter is dead. I'll think on that too, Judge. The fact that she lost her unborn baby, this is no different, Your Honor, than being told your bone was broken or the bullet perforated your liver. These people that have testified to these injuries don't know it because they've seen it. They know it because they've been told it by doctors, and they've lived with the consequences. And here, to not permit her the opportunity to describe her injury, an injury, significant injury of the loss of this unborn baby that she just had confirmed was alive earlier that day, would put her in a far different position than all the other victims who've been allowed to testify about their injuries. The fact that she still uses oxygen at night, I think, goes to the extent of her injury, Your Honor. And there's a way to do this without belaboring every single consequence. But certainly they have to know the fact that she lost part of her lung and the consequences of it through a couple questions and answers is not unfairly prejudicial, but is a measure of the injury that the defendant inflicted. And that includes the bullet fragments that remain in her body. We've had several people, including today, witnesses testify about shot that remains in their torso, in their limbs, and even in their face. She was at Craig Rehab Hospital from August 12th to December 13th. That singular fact does not create unfair prejudice, Your Honor. If we were to go down the road of every single thing that she had to endure, and there's a ton, over those 16 months, that would be potentially unfairly prejudicial. But the fact that their injury was such that she was at Craig Hospital for that period of time, Your Honor, I don't believe is. And I see Ms. Brady standing up. Should I stop talking?
He just said from August 12th to December 13th. I just wanted to make sure that the record was clear. It's from August of 2012 to December of 2013.
That's how I understood.
And thank you, Ms. Brady. If I misstated that, thank you for clearing that up. The ongoing infections, her falling, the funeral information, while I think that is relevant, Your Honor, incredibly relevant under 401, I do also think that there is a legitimate 403 argument to those aspects of this. And if I've missed something, Judge, would you tell me and I'll give you my thought on it?
So on the string of things, you agree that those should not be admitted?
Well, not on the entire string, Judge, and thank you for catching me up on that. There are some things where she talked about having to figure out how to use a spoon again is a measure of how that injury has affected her in a different way. They can be told that she's paralyzed as a result of this and that she can't walk, but to not understand how it's affected the rest of her body and her limbs, I think it gives them a false impression of the extent of the injury. The funeral part, I'd love the jury to be able to hear that, and maybe someday they will. The falling down, all of those other things. But I do think that at some point we get into the area of 403 if the court permits all of the other prior things in. Is there anything else, Your Honor, I might answer?
I think Ms. Brady listed nerve pain as one of the string of things. Is that something that you are agreeing to not include, or do you want to respond to that?
I think nerve pain, Your Honor, should be admissible. I do not think that's unfairly prejudicial. I do think if we were to ask for a string of examples of how that nerve pain manifests itself, that would be 403. But the fact that she suffers nerve pain and to ask her what that means in a limited capacity, I don't.
And the last thing I have is showing her a photograph of her daughter and asking if she ever saw her alive again after the movie.
Judge, honestly, with all the respect in the world due to Ms. Brady, it is inexplicable to me that we could go through the testimony of this mother and not show her a picture of her daughter and not only have her identify that daughter, but at some point during this discuss with her the death of her daughter and whether she's seen her again. And I don't know that I would use those words, Judge, but certainly the picture, showing her the picture, has to be something that we allow. That can't be unfairly prejudicial.
Okay, thank you. All right, I'm going to think about these things. Ms. Brady, I'm sorry, did you want to add something? Why don't you go to the microphone?
About the picture, Your Honor, I would just ask, what is the relevance of that? I mean, I think the point of that is so Ashley will start crying, as would any mother. It is to start crying, to evoke sympathy from the jury, and there's no relevance. There's no dispute that Veronica is Ashley's child, that Veronica died, that is a tragic, tragic occurrence. If there was any relevance, I wouldn't object. There's no relevance, and extreme prejudicial evoking of sympathy from the jury. Everyone in this courtroom will be heartbroken to watch Ashley see a picture of her daughter, and that's the point of showing the picture. With all due respect to Mr. Brockler, that's the point of it. It's not because anyone in here doubts that Veronica is Ashley's daughter, that Veronica died, that is heartbreaking. And so I see no relevance. I get why you would want to do it, but this is a trial, and there has to be relevance to it, and the relevance has to overcome the prejudicial effect. And I think this is an easy decision, that the prejudice of that way, way, way outweighs the relevance. So that's my last comment.
All right, so both parties believe it's an easy decision, but both parties come out different ways. All right, fair enough. Thank you. All right, is there anything else we need to talk about at this time on behalf